Hello students, and welcome to Ethical and Legal Issues in Healthcare. Today we'll be talking about workplace regulation. Workplace regulation. Okay, so the three main pieces of legislation that we'll be talking about is the Fair Work Act of 2009, the Workers' Compensation and Injury Management Act of 2008, and the Work Health and Safety Act of 2012, which was previously in fact known as the Occupational Health and Safety Act. So as I mentioned, there are three main legislative tools governing workplace relations. The Fair Work Act came about in 2009 and introduced the idea of modern awards, and we'll talk about that in just a few moments. The Workplace or Workers' Compensation and Injury Management Act of 2008, which governs return to work and injury at work in the course of employment, and the Work Health and Safety Act, which looks at preventative strategies around health and safety in the workplace. So before we actually start looking at this idea of workplace relations, it's important first of all to make a distinction between who we're actually talking about as being covered by these legislative tools. There's been a lot of debate, I guess, in case law, and often it comes out in terms of interpretation by judges as to what is considered an employee relationship and what is considered to be a contractor relationship, because these legislative tools or this legislation covers employee-employer relationships, not contractor relationships. And really, in terms of what constitutes an employee relationship as opposed to a contractor relationship, goes to a couple of things, or goes to more than a couple, goes to several things. The contract of employment and what the contract of employment seems to indicate in terms of the relationship, the level of control around the person's work conduct. What that means is how much work they actually do for this particular employer, and the standard is usually 80% or above. The totality of the relationship in terms of whether they wear a uniform, in terms of whether they sign in or out, in terms of whether they're required to actually have their own equipment or that equipment is supplied by the organisation or by the employer. The need for development training and who pays for that, the need for insurance and who pays for that, whether the person attends meetings, etc. And that, very broadly defined, is the control test. So how much control does the organisation have about that individual's work? So it's about looking at the totality of the relationship. So if there is not much control and there is actually deemed to be a contractor relationship with the employer, then it's a contract of service. It's discrete services which are actually undertaken, rather than a contract for service, which is where direction and execution of the work is undertaken under the employer's umbrella and governance, if you like. So you need to be mindful of that as actually, governing the overall interpretation of who is actually covered by this legislation. So let's move on to the Fair Work Act of 2009. It's a little bit dated now, but the Fair Work Act abolished the use of Australian workplace agreements, which were negotiated between employer and the workers of a particular workplace, and endorsed certified agreements. What does the Fair Work Act actually do? It sets minimum standards for workplace relations. So what it did was introduced modern awards and set minimum employment conditions. There was a review of the Fair Work Act in July 2012, which included a list of recommendations as to what needed to actually change moving forward. But I'd encourage you to actually have a look at the different Fair Work and the modern awards under the Fair Work Act, which are actually put in place, to have a look at some of those minimum standards. It includes things like penalty rates, the hourly rate, the leave entitlements. And I'm sure for those of you who are already undertaking some work in some capacity, you might well be familiar with that legislation. But it's an interesting point of reference to have a look at what you are in fact paid and what modern award would cover the kind of work that in fact you actually do, and whether your rights are actually being observed. The second legislation is the Workers' Compensation and Injury Management Act of 1998. So the Workers' Compensation Act is a no-fault based system. What that actually means is as long as the injury actually happened in the course of employment, it's actually covered as a workers' compensation injury. Now that includes workplace functions. So what I mean by that is Christmas parties that work might actually endorse or pay for. It might include staff meetings that are out of work hours, or, sometimes you hear about, particularly in corporate settings, going away for the weekend with your work colleagues, etc., etc. So that would in fact be defined as in the course of employment because you're there for the purposes of work. So it's a no-fault based system, which means it doesn't matter why the injury happened. It might be that the employee was acting silly, they were negligent in their own safety, although there would be a contributory negligence defence there. But overall, it's a no-fault based system, which means that if it happens in the course of employment, it would actually be accepted as a workers' compensation injury. And under the Workplace Compensation and Injury Management Act, there are a number of entitlements for injured workers in terms of their rehabilitation, their medical expenses and lost wages whilst they're recovering from their injury. So under the Act, compensation is limited to weekly payments, but also a lump sum compensation for death and specific injuries. You might also sue under common law, which is that negligence claim, but the permanent impairment must reach a threshold of 15% or more. And this was one of the changes which came about in 1998 as a result of some fairly expensive compensation claims that were paid out and a risk that the insurance industry would actually collapse under the amounts that were actually being given to injured workers for their injuries. So there's caps now, limits on what can actually be paid. So the employer pays compensation to the worker, and in the event, now workers' compensation is actually a legal requirement for all employers in New South Wales, but if for whatever reason an employer didn't actually have workers' compensation insurance, then there's a statutory fund, which means it's a government kitty or a government fund which actually goes to pay uninsured or employees of uninsured employers. So that's there as a bit of a safety guard. Okay, so as we mentioned, workers' compensation would cover workers, not contractors, and a worker is defined as a person working under a contract of employment. The employer is strictly liable to any employee who suffers injury, disease or illness out of the course of their employment. Okay, so up until quite recently, course of employment used to include lunch and journey claims, so to and from work. But in fact, there has been recent changes in 2012 to make eligibility for journey claims not covered, and it's just covered under CTP insurance normally. And as I mentioned, it's strict liability, which means it's a no-fault based system as long as it actually happens in the course of employment. So this is just a pictorial slide here for you to have a look at in terms of the quantification under common law of the different parts of the body and the money in terms of a lump sum payment which might actually be paid to an injured worker. Interestingly, the rehabilitation provisions under the Workers' Compensation Act also allow for rehabilitation of an injured worker. So when they can't in fact go back to the kind of work that they were doing before, some assistance to get into an alternate type of employment that's suitable given the person's restrictions. The next piece of legislation that I'd like to talk to you about very quickly is the Work Health and Safety Act of 2012, which used to be called the Occupational Health and Safety Act. So as you can actually see here, the main aim of the Work Health and Safety Act is it's prevention. It's to ensure the health, safety and welfare of people in the workplace. It's preventative strategies. So all of those risk assessments, the audits that are actually done, the OH&S or the Work Health and Safety Committees, which are usually set up by employees of a particular organisation to look at the health and safety initiatives of a workplace and make recommendations to management. So the emphasis in the Work Health and Safety Act is consultation with workers and consultation with employees to have a look at what needs to be done to ensure not only the physical health of employees but also the psychological health. And there's been a lot of material and a lot of work most recently looking at anxiety in the workplace, looking at stress, looking at mental health initiatives as well in relation to ensuring that individuals feel safe in their workplaces against harassment or against bullying. And there's been some recent changes in terms of work health and safety with the establishment of iCare as opposed to WorkCover New South Wales, where each state had their own regulatory authority and more of a national benchmark or a national standard. So again, if this is a topic of interest to you, I'd encourage you to go back and have a look at the iCare website and have a look at some of the initiatives there in terms of the benchmarks to nationalise these initiatives. Okay, and that brings us to an end for today's session.